Hello, good evening. You're welcome to this special edition of the AG High Agri Legal Practice Training. We actually started it earlier today. We crossed through section about 3 p.m. and lasted for about 2 hours. Not everybody who indicated interest participated in that particular session. So we decided to come up with this one to enable those people who were not able to participate in the first uh, series to participate right in this particular segment of the training. Uh, I want to say that hybrid legal practice is a new normal. You agree with me that during the COVID-19, the climax of the COVID-19 pandemic, there was virtual law practice. But after the COVID-19 pandemic, it's expected that there would be some changes, and this is one of the new changes that the COVID-19 pandemic has actually brought. And, it's actually brought about hybrid legal practice. During the COVID-19 pandemic, we had the climax of the COVID-19 pandemic, we had hybrid legal practice, virtual practice. Now that the COVID-19 is actually, we say, subsiding because of the rollout of the vaccines, um, we now have movement restriction orders being suspended. That's the case for me. But that does not mean that COVID-19 is totally gone. So what we now have is a new way of practicing law, which may not be predominantly virtual as the case would be. Rather, what we have now is hybrid. So hybrid is new normal. So it's expected that you upskill and understand how it works. As posted, some weeks ago or some days ago, I guess, I did say that this particular training will focus on how we can initiate highly contentious uh, matters, uh, which are basically hybrid related. Uh, Non-contentious matters, as the case may be, sometimes divorce related matters are non-contentious. So I actually classify such matters under the contentious matters category. But basically, of course, we all know very well that divorce petitions are not as serious as very serious uh, contentious matters that we know as far as civil litigation is concerned. Sometimes most uh, divorce petitions or some of the divorce petitions as case will be are not contended. So if they are not contended, of course you will say that they are not contentious. But when they are contended, they become uh, contentious. So that's we don't want to say much. We don't want to discuss too much uh, concerning the theories. Our focus is on the practicals. How do we initiate uh, contentious matters in a hybrid way? So these are some of the things that we're going to look at. Uh, before we proceed, it's important that we look at, we know what we can safely call the structures of hybrid hearing or the nature of hybrid hearing. Uh, we've actually crafted, a particular structure for it, and I'm going to do a screen share for you to understand what we're talking about. Thereafter, I'll proceed to explain some other things that we actually need to do. So let me go straight to the screen share. Okay, as you can see on the screen, we have a hybrid legal practice training, the structures of hybrid legal practice, the 5 virtual office model. Now, just take a look at what we have here. Now, there are different structures. There are different subsets, under the structure, there are about 8. So this is the structure the hybrid legal practice takes. Here, the first one here, you have the lawyer representing clients, provide both parties are in the brick and mortar court to give evidence. So this is the first structure of the hybrid legal practice. The lawyer representing client and motor, while both parties are in a brick and mortar court to give evidence. That's the first one. Then the second one is both lawyers representing clients in court while both parties are giving evidence in the brick and mortar court. So that's the second structure. We have the third, which is one lawyer represents his or her client in court physically, while the client gives evidence remotely through video conferencing tools. So you look at this one, there was very much different from the first and the second. One lawyer represents his or her client in court physically, while the client gives evidence remotely through video conferencing tools. And number 4 here, you have both lawyers represent their clients in person, while their clients give evidence in court remotely. So this number 4 is different from number 3. So the first number 3 is one lawyer represents a client in court physically, while the client gives evidence through video conferencing tools. Then the other one here, number 5, is both lawyers represent their clients physically, while one of the parties gives evidence remotely. Then number 7, you have by order of court, parties are in the physical court attending proceedings while their lawyers address court remotely. I'm sorry for the wrong number here. That's we have what it means is that we have number 5. After number 4, we have number 6. What you have there is supposed to be number 6. So by order of court, parties are in the physical court attending proceedings while their lawyers address court remotely. Then number 7, both lawyers move their motions remotely while parties are in brick and mortar courts. Why number 8, one of the lawyers moves his motion remotely while parties are in court. Then number 9 is a lawyer holds meeting with his or her client remotely from his own main office while he or she joins the meeting from wherever convenient for him. So that is it. That's the structure of hybrid legal practice. In other words, we have about 9 there, but our focus there is on litigation. So some of the structures captured there, the subsets, captured there, they are actually basically for non-litigation matters. So, but this one is for litigation. Our focus in this particular training is on hybrid legal practice as it relates to litigation. So we have hybrid legal practice as it relates to non-litigation matters. We have hybrid legal practice as it relates to litigation. So our focus here is on one that relates to litigation. That is what we are talking about here. So now the question is, how do you commence a hybrid legal a suit which should be in the form of the hybrid hearing? So there's a question that we have to program our mind, to enable us, to start whatever we're going to discuss, today. How do we commence it? So for you to commence a suit in a hybrid, for a hybrid suit, a suit designed for hybrid hearing, what do you need to do? Of course, we know the general mode of commencing proceedings in our courts in Nigeria. But our focus will be on the means the commencement of suit by the rate of summons. So that is our focus because this is actually where you have contentious matters. The other ones are not actually as contentious as this one because in this case you require evidence. Evidence is going to be led. So that is what our focus is all about here. Now, what you need to do in this particular form is this. Now, take a look at the screen share that I'm going to do next. Okay. So let me start with highly contentious matters for writs, actions that are commenced by way of writs of summons. This for highly contentious matters. Just take a look at this. Now, the first thing you do is to initiate the action via ex parte motion for virtual witness deposition in court. Very important. For actions commenced by the writ of summons, the first thing you do is to bring an application for virtual witness deposition in court. Remember, by the rules of court, the processes, the statement of claim, list of documents, witness statement on both have got to be front-loaded. And because all these processes have got to be front-loaded, there is no way you can file your suit without front-loading your witness statement on oath. So because of that, the first thing you need to do is to file an ex parte motion for virtual witness deposition on oath. You bring it by the relevant provisions of the Constitution of the Federal Republic of Nigeria, specifically Section 36, as it relates to public hearing. Then the NC COVID-19 directives of May 2020, there are provisions there. Shortly, I'm going to show you. Then you rely on the inherent jurisdiction of the court, the relevant provision. We have relevant provisions in various rules of court concerning it. So that is it. So the first thing you do is to bring an application, an ex parte motion for virtual witness deposition on oath. Then when the court has granted it, the next thing you do is to now file your virtual witness, your writ of summons, statement of claim, list of documents. Then you front load your virtual witness deposition on oath alongside with it. So this foundation has got to be laid properly so that you will understand very well. What it means that you cannot commence the suit without bringing this particular application, this ex parte application for virtual witness deposition on oath. Take note, this is this has to do with a hybrid hearing matter that is commenced by the council. You have the court-ordered hybrid hearing matter. Then you have the council-ordered, council-initiated hybrid hearing matter. This one is the court-ordered, council-initiated hybrid hearing matter. The council-initiated, the court-ordered hybrid hearing matters, in most cases, the court tells you what to do. And most of the courts actually, they are not really poised to read. What actually concerns them is when you have got to where you have got to go for your judgment. So when they want to give judgment, they can do it. But you, the lawyer, you have got to know how to initiate this kind of hybrid related matters. So that is why you need to understand the procedure. You don't have books on them, as a matter of fact. In fact, the first virtual witness deposition on oath case in Nigeria is the case of Ogedegbe and Ogedegbe, a case which I initiated here in Warri in a particular court and you have it online, it's all over the place, as a matter of fact. That was the first known case on virtual witness deposition on oath in Nigeria. So, and before I embarked on it, I actually read the rules very well. Then I created that particular mode of commencing the suit, which the court okayed in that particular case, and that has become the procedure today. Pending when the court will come up with a procedure, but for now, this is a procedure. There is really no need because this one is something that actually uh, has opened the floodgates for virtual uh, hearing in Nigeria today, and virtual comment how to commence suits, virtually when the witness is not in Nigeria, is based abroad, or is maybe somehow not disposed to coming to court to depose a fact virtually, physically. So you can do that virtually. So now you can see that we have number 5 there, which has to do with motion expected for virtual service origin processes. Assuming the adverse party is not actually in is not in uh, is not you cannot locate the adverse party. So while you are filing your suit, you have to also bring an application for virtual service of originating processes. So that is the essence of that particular motion there, which you can see on the screen. Thereafter, you bring an application for virtual motion or notice for virtual hearing. Please, that one we did it twice, it's all of the one. Motion or notice for virtual hearing. That is the last application that you have got to bring. You observe that this one and the first one, you have two applications, two ex parte applications, and one motion on notice. The one on notice is for virtual hearing, while the ex parte is the two ex partes are actually based on virtual witness position on oath, and while the other one is on virtual service of the originating processes, in most cases by the WhatsApp contact of the party, of the adverse party, or by the email address of the adverse party, or by any other means as the case may be. It could be by way of advertisements, any of the online news platforms as the case may be, or the regular dailies that we know in Nigeria. So that is it. Now, let us go to for divorce petition. What do we do here when you want to initiate a divorce petition and your client is not in Nigeria? Your client is abroad. What do you do? In this particular case, you bring an ex parte application for virtual affidavit of verification of petition, ex parte application for virtual affidavit of verification of petition, very, very important. And you have your notice of petition, your petition itself, certificate relating to conciliation, list of documents, ex parte, motion ex parte for virtual service of the petition and the accompanying processes, then motion or notice for virtual hearing. So look at you have seven items listed here. The first one is motion ex parte for virtual affidavit of verification of petition, notice of petition, petition itself, certificate relating to conciliation, list of documents, motion ex parte for virtual service of the petition and the accompanying processes, and motion of notice for virtual hearing. So that is it. The question is, what is the difference between this and the one I discussed earlier on? The one I discussed earlier on was actually for contentious matters. You know, in contentious matters, you have to front load all these documents. The one for the divorce petition, in fact, it is not as a matter of fact that you can actually do that. You can file your relevant processes then you bring an ex parte application for the virtual affidavit of verification petition. That does not in any way makes the suit incompetent. There is nowhere we actually have in the matrimonial process rules that such will make it incompetent, as the case may be. So it's important that we take note of that. So the difference between this one and the other one is that you can file your notice of petition, your petition certificate related, then you file your ex parte application for verification of petition. So before the petition will be heard, the ex parte application for verification of petition has got to be heard. The ex parte application or motion ex parte for virtual service of the petition and the accompanying processes have got to be heard before the notice of before the petition will be heard. So that is the difference between this one and the other one and the first one. So that is actually the difference between the two. So it's important that you take note of it so that you don't have a problem with it, as the case may be. So that is it. So now let us go straight to the suit. We now have to look at some of the processes. Okay. We have to close that. So that is it. So this is actually what you need to look at. Now, in the training earlier the day, and I talked about, I did a practical demonstration. I showed the participants the processes, filed, how to couch the reliefs and the affidavits or whatever. Let me see what I can do about it to take us down to that particular place. That is it.